This is the time and date for the sentencing in the matter of Peoples versus Ricky McCall Matthysse. Mr. Matthysse is here, also present, and his lawyer Casey Strong. Prosecuting attorney Deborah Davis is here, and Matt Huff is here from the probation department. Matt and I have had a number of discussions about this case. Mr. Matthysse had two drinking driving instances in a short period of time. This incident occurred in March of 2025. Defendant entered a plea of no contest to operating while impaired, I believe is the way this went.
Pause right here. Operating while impaired. Not quite the same as a full DUI conviction, but don't be fooled. This plea still carries serious consequences. What do you think? Should first-time offenders get the chance to go to sobriety court? Or should consequences be harsher to make the lesson stick? Drop your thoughts below.
And the matter was referred to sobriety court. Matt has spent a lot of time on this. I think Strong has as well. Anyway, troubling set of facts, troubling circumstance, and some logistical issues which could be roadblocks. Ms. Strong, what would you like me to know?
Thank you, Your Honor. In review of the report provided by Mr. Huff, I would like to thank Mr. Huff and the Sobriety Court team for all the work that they have put into this, and recognize that Mr. Matthysse did complete the evaluation with Spencer yesterday. They had a 3-hour meeting, and it's my understanding that Spencer was going to contact someone with the court to have a discussion regarding that. If the court has received that communication, is prepared to move forward today, we can do that. Otherwise, if we are still waiting on that report from Spencer for possibly qualifying Mr. Matthysse for sobriety court, I would ask for an adjournment. Mr. Matthysse is 23 years old, and the court has looked at the set of facts and has noted that there are some things that they're concerned about, which makes Mr. Matthysse a candidate for sobriety court. And my knowledge of sobriety court, it's a wonderful program that will allow Mr. Matthysse to rise to the occasion, participate in the program, and get back on track. We all know, and we can all relate to the fact of not having a driver's license and the impact that can have on employment.
This is the heart of the pitch. Give a young man a structured second chance before the world hits him harder than this courtroom ever could. But here's the twist. Judges don't just look at facts, they look at future risk. Is Ricky a comeback story waiting to happen, or a ticking time bomb? Let's keep watching.
Schooling the rest of his life until that gets resolved. And not only the driver's license participation issue, but also just having some kind of a support system to get plugged into young to address this and resolve this issue before he goes forth into the world. Mr. Matthysse retained me on this case. He has been early, he has been communicative, he has been present for every court hearing and every communication. I think that he would take this sobriety court participation very seriously, and I would ask the court to consider him for that.
Debbie, before I hear from you, let me tell you what my concerns are. One, I'm not sure Mr. Matthysse is mature enough to do this.
Boom, there it is. The judge calls it out. Immature and impulsive. That's not just casual language in legal terms. It's a red flag. Courts use patterns of recklessness to predict repeat offenses. Do you agree with this method, or does everyone deserve a clean slate every time?
We don't have the greatest track record with very young people, although we just had a very successful young man graduate at 24, and he started the program at 23. In fact, it's from the Mendon area, like Mr. Matthysse is. He did an outstanding job, and I told him he might have made the road easier for the next people. But this case is full of immature, impulsive behavior. The other issue is the logistics of doing this. If he's going to be working second shift at International Paper, that he won't be able to participate without considerable grace from his employer. So one option I discussed with Matt is starting him on a regular sentence with a probation, and I can always amend it and transfer it to sobriety court. But I don't think we've worked out the logistics from his job. As I understand it, your hours are, what are your hours at work?
I usually work 3 to 11, sometimes 3 to 3.
And would you elaborate on what you told me in the conference room?
So I talked to my supervisor, and she said as long as somebody, which I already talked to them and they agreed, the shift before will stay after so I could do my Zoom calls.
We've had people from International Paper. We had one guy, and they were working 12-hour days. He was in our program and the company worked with him. And we've had another one, at least one more, but that guy sticks out because he was working so many hours, and he did manage to participate in the program. At some point, the wheels fell off after he graduated, but he did, I think, complete the program. Ms. Strong mentions if you get convicted of this, your license is going to be revoked, meaning it'll be 5 years before you're eligible to get a driver's license back. One of my concerns is that she's been more interested in getting you into sobriety court than maybe you have been.
And here comes the prosecutor gloves off. What you're about to hear isn't just about a single mistake, it's a pattern. And in court, patterns tell a powerful story. Watch how she lays out his history like a timeline of red flags.
Although you've been here each time, you've been polite, you've been respectful, you dress respectfully, as though you take this seriously. We understand the session you had with Spencer Price yesterday was 3 hours long, which was a good sign that you were willing to engage and a lot of information was exchanged. And her goal, and I guess maybe ours, would be to change your behavior before you screw up the rest of your life, or worse, shorten your life with a tree one night. Having said all that, Ms. Davis, what's your position here?
Your Honor, Mr. Mathisse's history is concerning. He's had alcohol-related and substance-related issues since his juvenile days. I guess what is bothersome as well is that Mr. Matthysse is aware that on August 26th of 2023,
Silence can be deadly in court and not in the cool, dramatic way. When you're on probation, full disclosure isn't optional. Keeping secrets, that's how trust evaporates fast. Here's a question for you. Is silence a lie when you're legally expected to speak up?
he was drunk at the Vikings clubhouse doing burnouts in the driveway, took off, hit a neighbor's yard decorations, took off again, crashed into some irrigation equipment outside of Three Rivers, admitted to marijuana use, that somebody had laced his marijuana at the clubhouse. Unfortunately, that case didn't get reported to his then probation agent because he was on probation at the time. It was sent for further investigation because of it being an impaired with substances. And unfortunately, it wasn't followed up on until 2 days after he was released from his probation. So 2 days after being released, a new complaint came out of the office in March of 2024 for the incident that had occurred in August of 23. It frustrates me that he knew that he had been taken into custody or, that this was potentially pending, and yet he didn't say a word to his probation agent for, let's see, August through December, and then December through March, when he was successfully released a year early on his probation. Fast forward, so that case, then he's upset because, well, how am I having a warrant if I just got successfully dismissed? He's calling the court, according to the ROA. Well,
as it turns out,
it got dismissed.
that case in the middle just disappeared.
Right. And so I had to dig out the facts on that one. And it turns out that last year in October, it had to be dismissed because there had not been the follow-up regarding the substances that he had used. That being said, it doesn't mean that it didn't happen. He didn't get a conviction for it, but there were certainly a lot of concerning facts. And the fact that he didn't bring this police contact up to his probation agent during that first probation is very frustrating. And to add on to that, apparently the Secretary of State had still shown that second one on his record because he called the court complaining about his insurance
Yeah,
costs.
this was screwy because they abstracted the case that he got dismissed and didn't abstract the case that he was convicted of.
And I wasn't certain on that. I mean, there are times where Secretary of State they'll get the abstract when the warrant is issued or the ticket is issued. And then if we don't end up charging, we end up sending a letter to them saying we ended up not charging for whatever reason. But that was on February 21st of 25. He calls the court complaining. And then on 3/1 of 25, so about a week later, we have this charge where he's out at a local bar drinking with his father. Dad takes him home, but then he, for some reason, decides to get in his car and do burnouts in the driveway.
To piss off his neighbors.
Yeah, and start his own car on fire.
Yes.
So I also noted from the dispatch notes that whoever called this in said he usually races up and down the road, which is concerning. If this is a person who wants to have a license in St. Joseph County with the significant history that he's got, I have concerns. And he was also in the household where Mercedes Wyrick OD'd while awaiting the case.
How is that relevant?
Because there are substance abuse issues in the family and him. And if he wants to have a license in St. Joseph County and drive around on these roads where we all travel, then I think we have a duty to make sure that he understands how serious we are about the use of substances when he's driving.
Well, when we were aware of all that, and Matt and I have been struggling with it, and you weren't in charge in 2023 and 2024. And this happened more than a couple of times where somebody would get arrested, they'd get released, that never got followed up on, and essentially that one was a freebie. And we were aware of the conduct. Then this one, yeah, he's out drinking with his dad. So apparently his father's not real worried about his circumstance. Takes him home, and then his parents are in the house, apparently asleep, when he's out burning up and down the road and sets his car on fire. Police put it out with a fire extinguisher, and he was very, very intoxicated. And his reason for doing it was because he wanted to piss off the neighbors. So when I said we're talking about immature conduct, that's what we're talking about, which makes me question whether he's mature enough to do this. So I guess the question is, do we just give him a jail sentence and wait till the next time? Or do we try to intervene with supervision, try to change the course? I agree with you, Ms. Davis. This is very serious stuff, and Matt has been struggling with it. We've yet to receive the report from Spencer Price, who I trust his judgment. He's an original continuing member of our Sobriety Court team. So one option is to just do a sentence. Either give him a bunch of jail time, make him lose his job, put him on a traditional probation, or try sobriety court with the supervision. The plea was no contest to impaired, so the court is limited to 93 days. And there's a carrot. The carrot is a reduction of jail sentence and a potential license. So I understand your position on this and probably frustration. He did call the court during that time asking about the warrant. I don't know what the deal was between him and his probation officer. I guess he just assumed we knew about it. According to the notes from the clerk, defendant called October 7th. He just found out he had the warrant. He didn't understand how he got a successful discharge in his other case if he had this warrant. I told him we got the new complaint 2 days after his discharge from probation. So he then came in 2 days later once he found out about the warrant and presented himself. And Ms. Strong got involved. So then the case gets dismissed, and then there was an issue about which was which. So He turns himself in, the warrant issues, and again, you were gone at this point. Warrant issues October of 2024. Defendant calls, turns himself in, gets arraigned, and 7 days later, whoever authorized it dismissed it, and then it never got rebrought. So are you outright opposed